Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-1048 et al. Don't Waste Michigan et al. Petitioners versus U.S. Nuclear Regulatory Commission and United States of America. Ms. Curran for the petitioners Beyond Nuclear Inc. Mr. Taylor for the petitioners Don't Waste Michigan et al. Mr. Counter for the petitioner Fascon Land and Minerals Limited. Mr. Averback for the respondents. Mr. Fack for the intervener.
Ms. Curran, before you begin, I'd just like to note that today marks the first day of sitting for our newest colleague, Florence Pan. Judge Pan, welcome to the DC Circuit.
Thank you.
Please proceed.
Good morning, Your Honors. My name is Diane Curran. I'm here for Beyond Nuclear. With me on the front row, in the front row is my co-counsel, Rudy Goldstein. I'd like to take 7 minutes for my opening argument. In this case, all parties agree that the NRC issued a license that would violate the Nuclear Waste Policy Act if one of its conditions were fulfilled by allowing the licensee to rely on contracts with the U.S. Department of Energy to take federal ownership and financial responsibility for interim spent fuel stored at the licensee's private facility before the opening of a federal repository for permanent disposal. The only issue before this court is whether you should disregard the plain terms of the license condition as suggested by the NRC based on extraneous promises by the agency that fulfillment of the unlawful condition will never be carried out or allowed until Congress changes the law.
Forget about the extraneous promises. Let's just look at the face of the condition. It can be lawfully satisfied to the extent they are taking waste from privately owned waste for which a private entity has title.
That's absolutely true, Your Honor. And the license contains language that would allow private fuel interim storage partners to store federally owned spent fuel. It's our position that every word of this license has to be read. The license condition has to be fully enforceable at the time.
You say that's your position, but what supports that? Why? Could I finish my sentence? Why? What is it that requires that every part of the license provision be enforceable?
Sorry, Your Honor, I couldn't hear.
I'm sorry. What is it that says you said you believe that all provisions of the license requirement must be enforceable, but what requires that?
Well, it's not just
what do you cite for that proposition?
It is the private fuel storage case cited at page 8 of our reply brief. This is NRC's own jurisprudence that license conditions should be fulfillable at the time the license is approved. The point of a license condition is that it should be something that's easy to fulfill administratively without having to question what the law might be.
Well, one of them is easy to fulfill, right?
I'm sorry?
One of them is easy to fulfill.
Yes, but all the words of the license must be.
You keep stating that, but I'm asking you what your authority is for that.
My authority is the Administrative Procedure Act and the NRC's own jurisprudence.
All right, let's start with the Administrative Procedure Act. What in that requires that every word be enforceable?
The NRC may not act contrary to the law. The Administrative Procedure does not.
Why are they acting contrary to the law? They say, what's contrary to law here?
They have approved a license that would allow the licensee to take unlawful conduct, that would approve unlawful conduct under the Nuclear Waste Policy Act. There's no temporal exception in the Administrative Procedure Act. It doesn't say if the law changes in the future, it's okay to put an unlawful condition in right now. The law has to be met at the time of licensing. That's basic APA requirement, that the agency may not act contrary to law. And in this case, the NRC has admitted that its whole purpose here is to create a license that is valid now, that does not need to be amended in the future. So they can't have it both ways. They can't tell you, well, you can disregard this unlawful language now, but it's going to be effective if and when the law changes so that this company can bid for NRC contracts without having to amend the license. That's at page 468 of the NRC's decision.
Suppose you're correct that the language in the license seeming to authorize arrangements for government-owned waste is unlawful. But there's still the other language authorizing arrangements with privately owned waste, and you have no argument against that. Why wouldn't we, at most, just excise the offending language and sever the rest? There's no reason why the provision can't operate as applied to privately owned waste.
Your Honor, it would certainly address our concerns about the language of the license if you were to sever the unlawful language, and that is very well accepted remedy in the court. The only problem here is that we also asked the NRC not to go ahead with this licensing proceeding in the first place because the license applicant was asking the NRC to take action that was contrary to the Nuclear Waste Policy Act. That would not be resolved, and we would ask you to declare that the NRC should not entertain license applications that are clearly unlawful. At the time, we asked the NRC to sever, to tell the applicant, you may not include that provision.
Excuse me. Why, if we granted the relief that Judge Katsas suggests, wouldn't that solve the problem completely?
It would not solve the
Understand why?
problem that the NRC went ahead with a licensing proceeding. It took many years that included an unlawful provision.
But if the unlawful provision is gone, what's left?
What's left is that the NRC has stated that it can issue a license that violates the law if the law changes. And that's where we get to the separation of powers problem.
Wait, before you go to separation of powers, let me just give you a slight modification of Judge Katsas' question. Suppose we said, instead of excising that provision, suppose we said in our opinion that our opinion denying the petition is based on the assurances of the United States government that the unlawful provision will never be implemented. Wouldn't that do it too?
Your Honor, I still think that the law requires the NRC to issue a license that is lawful at the time of issue.
So then your answer to Judge Katsas' question is no, right?
No.
It wouldn't satisfy.
No, but severing that provision would address the problem significantly.
May I ask a question? Ms. Curran, I think there might be a more simple way to approach this issue, and that is by focusing on the language of the contention that Beyond Nuclear filed. And so we are here reviewing the Commission's decision to uphold the board's decision to reject the contention. And the words of the contention are as follows. The proceeding must be dismissed because the central premise of ISP's application that the U.S. Department of Energy will be responsible for the spent fuel that is transported to and stored at the proposed interim facility violates the NWPA. That was the contention. So on its face, doesn't this contention fail to raise a genuine dispute about a material issue? Because it says the central premise is that the DOE will be responsible for the spent fuel that is transported and stored at the proposed interim facility. It doesn't acknowledge the alternative way, and so it's not the central premise, and so this contention was correctly rejected. We don't have to get into any of these legal arguments about, is this a legal thing or not? This contention fails.
But, Your Honor, the basis for the NRC's rejection of the contention was that there's no legal dispute that the license provision is currently unlawful. but the provision could never be fulfilled because the NRC and DOE would forbear from doing it. So that is the ruling that we are appealing.
The commission said in its ruling, Beyond Nuclear has not shown error in the board's interpretation of the legal force of the disputed license condition. So why can't we just uphold that and say your contention fails?
Well, that's where the catch-22 comes in here. The NRC said when we file a hearing request, we have to show there's a dispute with the license applicant about what the law requires. And the NRC said, well, there's no dispute here. Everyone agrees that this license condition would be unlawful if under current law, but nobody's going to fulfill it or enforce it. So we were caught in a catch-22. We can't win that game.
Well, my understanding is in the board's decision, it noted that you filed your contention. The NRC said there's no dispute about the illegality of one portion of this, and you didn't amend your contention. So the contention that they rejected fails. You didn't amend your contention to take this into account. So what we have before us is a contention that was rejected and apparently properly so on its face. I don't know that we need to get into any of this other argument.
But the contention said that it was the central claim of the license application, and that is a proper reading, and the central claim is invalid, that the DOE can store spent fuel. We did not argue.
But it's not the central claim because there's an alternative way to fund this, which is through people or I guess non-DOE title holders of spent fuel. So it's not the central premise, and your contention fails.
But the contention said that there is a claim in this license application that violates the Nuclear Waste Policy Act. We did not contest the lawful part of the license application that would allow private storage of spent fuel.
No, I understand what you intended, but you didn't say that in your contention, and the contention on its face, in my opinion, seems inadequate.
But, Your Honor, I also want to point out that we filed a motion to dismiss the entire proceeding, and the NRC referred it to the NRC's hearing notice is supposed to allow us an opportunity to litigate whether the license application fulfills the NRC's regulations for protection of health and safety. The issue of whether this license included a provision that violated the Nuclear Waste Policy Act was not really encompassed by the hearing notice. Therefore, we filed a motion to dismiss the proceeding, which the NRC refused to deal with. It would not rule on our claim and said, we're going to buck this to the licensing board, but our claim was not a dispute over whether NRC satisfied the NRC's, whether ISP satisfied the NRC's safety requirements. It was a threshold claim that the entire proceeding was unlawful. And so we're asking you to rule on that threshold claim.
No, I understand. So, but are you conceding that if the contention fails, then all that's before us is your motion to dismiss based on this?
Yes.
Okay, thank you.
Anything else?
No.
Thank you. We'll give you a few minutes on rebuttal. Mr. Taylor. Mr. Taylor.
Please the court. I'm Wally Taylor. I'm representing the Sierra Club and a coalition led by Don't Waste Michigan. Terry Lodge actually represents Don't Waste Michigan, and he's here in spirit. But we jointly briefed this case at the court's direction, so I'm arguing for all of the parties. We raised several issues relative to the contentions we filed in the NRC adjudicated proceeding. We also filed separate petitions for review regarding the environmental impact statement.
Yeah, I want to ask you about those. You have, as I count, 7 of those, right? You have 7 challenges to the environmental impact statement.
Yes.
And our this court's November 10 order directed that you include in your briefs an argument about jurisdiction, right?
Yes,
And you didn't, correct?
not in the initial brief, we did in the report.
Was there a reason for that?
Pardon?
Was there a reason for that? Why didn't you do it?
Primarily because of the page limit, or the word limitation, and
You were under direct order to include a jurisdictional discussion in your opening brief.
that we just overlooked it, Your Honor, and we're concerned about getting all of our arguments in the word limit.
And you know that, I mean, I know you've got 8 pages on it in your reply brief, but are you aware of this circuit's case law that raising arguments in a reply brief for the first time is unacceptable? It's a waiver of the argument?
Well, we were responding to the argument of the NRC and the United States.
But your jurisdictional argument should have been in your opening brief. It's too late to include it in the reply brief, and I didn't even see in your reply brief any explanation for this. Usually when a party waives or fails to that, they put in an argument about trying to explain to the court, well, we had these problems, you know, it's not jurisdictional, but you have none of that. In fact, your reply brief doesn't even acknowledge. The government pointed out in its brief that this court had ordered you to include the jurisdictional analysis in your opening brief. You hadn't done it, and the government says that's sufficient alone for us to dismiss these claims. No response to that in your reply brief.
Of course, the court can address the jurisdiction issue at any time, but we would ask the court to
Objections to jurisdiction are not forfeitable. Assertions of jurisdiction are forfeitable.
That's my explanation, Your Honor. I'm sorry.
Okay.
Well, why don't you go ahead? Court will decide this question, but you heard my question. It looks to me like just a classic forfeiture of an argument. It's not even that you failed and the government invoked waiver and you didn't respond. It's difficult for me to see how this court can hear any of those claims, challenges to the EIS.
Well, in a few seconds I have left, I would note that we.
Well, then let me just help forward your argument. So you have 6. If that's right, that leaves 6 challenges to the denial of intervention. That's the way I count it. You have 6 separate challenges to the denial of intervention. Which of those do you think, and those are properly before us, which of those do you think, which one is your most persuasive?
I was going to argue the transportation issue, Your Honor.
That's the most persuasive?
I believe that's the one that Tatel Club and West Michigan both.
Well, why don't you speak about that then?
Sure.
Okay.
Yes. That was Tatel Club's contention number 4. And we presented the expert opinions of Dr. Marvin Resnikoff and Dr. Gordon Thompson. ISP's environmental report, sections 4.2.6 and 4.2.8 did not adequately address those opinions. The environmental report does nothing more than create a dispute, justifying an evidentiary hearing, and that's sufficient for a contention to be admitted. We did set forth the standards for admission of contentions. The contention also.
Well, the commission said, as I understand what the commission said about this, it's that, I mean, I get your point. Transportation is a big part of this, but the commission said that ISP had identified a dozen representative routes, and you nowhere explain why that analysis was defective. And you haven't said in your brief why that commission finding about the inadequacy of your response was arbitrary and capricious.
There were 2 problems. First of all, there was a claim that transportation issues are irrelevant, and then also that.
What about could you answer my question about the representative routes?
Sure.
Specifically, please respond to that
Sure.
question. You didn't explain, you didn't say to the commission why you thought there was anything wrong with that analysis, right?
I think we pointed out that that the agency and ISP can't get by with saying, well, we don't know where the routes are going to be because the waste hasn't been shipped yet. But our argument is that it's going to be by rail. We know where the rail lines are. So there's, it doesn't take much imagination to know where the impacted communities and individuals will be. And that's why we felt that the commission was wrong in arguing that because the routes haven't been officially designated, that it was okay for ISP to just say that we don't know where the routes are going to be, so therefore we don't have to consider transportation.
Are there any other of these 6 you want to focus on in your time?
And as far as our contention on the transportation, those are the 2 main points that I did address the allegations in the environmental report with expert testimony, and that is sufficient for admission of the contentions, and that the routes are well enough known that we can say that ISP should have done a better job, and that the commission should have I should have allowed that contention into evidence.
You're into your rebuttal time, so. You are Mr. Canner for Baskin?
Yes.
Good morning.
Your Honor. Good morning. And may it please the court, Alan Canner for petitioners Baskin Land and Minerals and the Permian Basin Land and Royalty Owners. With court's permission, I've reserved 4 minutes. The NRC erred in denying Baskin's motion to reopen the record and file a new contention based on new information in the DEIS that was not in ISP's environmental report. The information was that the privately titled waste would not involve reimbursement to local government for emergency response and preparedness, as well as for infrastructure improvements. As you know, the original filing was for a DOE only facility with DOE transportation standards, which are stricter than NRC's general standards. Baskin's new contention was focused on local site-specific impacts and local cost-benefit analysis, which NRC is obligated by its regulations to evaluate. Specifically, we focused most of our new information on the stretch of the Permian Basin within the 50-mile radius of this facility. And the NRC and ISP agree that route will definitely be used. In that sense, the focus on site-specific information distinguishes our claim from that of the Sierra Club, which was talking about national information. And what we're looking for in the site-specific information is the fact that we don't really fully know what the rules are going to be, but they are obligated to at least explain the local issues with respect to emergency preparedness.
Mr. Canner, why weren't all of your claims ascertainable from the ER, from the environmental report?
It wasn't ascertainable. I mean, I think the assumption was that DOE standards would apply across the board. the DOE transport standards would be utilized across the board.
But the ER
The
didn't say
NRC
that.
says we should have seen this
Right.
coming. We should have seen this coming.
Right. Why?
I think it's just as likely that it would have been the DOE's regulations. And frankly, this ascertainability is not a part of the rules that we're dealing with here. They just ask if the language is different. The order we're appealing from the commission specifically says we agree the language is different.
You need to show good cause, right?
Say again?
You need to show good cause.
Yes, it's an elevated
Part of
standard.
that is that the contention wasn't fairly apparent.
Correct, Your
And I
Honor.
don't want to fight over the adjective, but
Correct. And we also feel that this was, unlike many other NRC proceedings, this was a brand new thing, very unique. CISF, there are regulations for the creation of an ISFSI, such as we have in the Bull Creek case. And they said Congress knew about this. There are also regulations for an MRS. This was new. It was constantly changing. The NRC in its order said, well, we can't stop them from changing the application. So I think that to shift the burden of ascertainability to us, in addition to the other burdens, this doesn't make sense in the context of this language, the pedigree of the program over time.
the environmental report on its face contemplates that you might have shipments involving DOE waste, or you might have shipments involving private waste. Indeed, the latter one, as we discussed earlier, is the only one that could happen.
Correct.
DOE would be responsible, as I understand it, for making the safety arrangements if it's DOE waste, but not otherwise. So why doesn't that pretty clearly signal that someone else is going to have to make arrangements for safe transportation if it's privately owned waste? And if that's not the federal government, who else is it going to be?
I'll tell you exactly why, Your Honor. Congress looked at the issue of transportation in the NWPA. They looked at transportation with respect to taking it to the final repository. Okay, this is not that. But Congress concluded the title should go to DOE and they should be responsible for transportation. This whole license is predicated on Congress changing the law to allow DOE to put its waste in a privately owned facility and commingle it with privately owned waste, privately titled waste. My position is, why wouldn't that law require DOE to do all the transport? DOE has a slew of regulations that are much stricter than anything NRC has done. To say that is an unreasonable assumption, and even to get into the subjective state of mind of the people filing contentions, I find sort of inconsistent.
So I'm sorry, are you saying there is a legal requirement for DOE to arrange for safe transportation even when the waste is privately owned? Or are you saying that's just so obvious that you couldn't even foresee that the states might have to?
If you were shipping to a final repository, I think we all agree the law is that DOE would do the shipping. I think we also agree that this license has a hypothetical in it. What if Congress passes a law allowing DOE to ship waste? Well, it follows that they would probably have DOE take title to that private waste.
But I mean, it's no secret that we're talking about something other than shipment to the final repository. Yucca Mountain's been on ice for 20 years.
But are we really? I mean, Congress with Yucca Mountain and the NRC, Congress decided it should go to a single-use location, deep geological repository. The NRC is now saying we can put this on top of the Permian Basin where oil and gas activities are going on. We can put it basically on a parking lot. We can put these casks on top of the parking lot. I don't know that one could reasonably assume that transportation would be left to private parties. As Your Honor recalls, from Bull Creek, there was a facility that was created. It ultimately was not usable because of different issues, but do you really think any private entity, a utility, would take the risk of shipping its waste? If there's going to be a change in the law, they're going to have DOE do the shipping, just like they did in the NWPA. That is not a far-fetched reading of this application, one that is unique. And so I think a little bit of deference and ever-changing, as the NRC admits. So a little bit of latitude, I think, is owed to the petitioner who's trying to focus on site-specific issues, which the NRC says are essential in their regulations. There are numerous places where they say that. We raise site-specific issues, and they refuse to hear any of them. All we request is that we have an opportunity to hear this. And one of the problems, Your Honor, you said earlier, and I'm not second-guessing or arguing outside my lane, you suggested, well, we could just excise the DOE part and go forward. The only problem with that is you have to understand the history of this proceeding. It started as a DOE-only facility. When you started commingling private waste, you necessarily created a certain element of confusion. The burden was on ISP or the NRC to clarify for people because NEPA, the Atomic Energy Act, all require that people to have an opportunity to participate. If they're not going to be clear in the first instance, they're not going to be thorough. Because face it, if you're going to file a contention, you're supposed to go to the environmental report, right? You're supposed to look at specific language, object to that language, explain all the information that you're going to use associated with that language. Where would we have pointed to in the environmental report that says, in fact, there would not be money for emergency response preparedness for privately titled waste? And if there's not, that changes the cost-benefit analysis. Right now, the NRC says it's a small to moderate benefit to this area in the Permian Basin to have this facility here, presumably, I guess, taxes or something. Nobody can say that with a straight face. I mean, you read Tommy Taylor's declaration, this is a huge burden on the community.
Thank you. Judge Tatel, anything else? Judge Pan?
Nope.
Thank you. We'll give you a minute or two on rebuttal. Let's hear from the government. Whenever you're ready.
May it please the court, my name is Andrew Averback from the United States Nuclear Regulatory Commission. I appear today on behalf of both the NRC and the United States. Each of the petitions for review in this matter should be dismissed or denied for a variety of reasons, ranging from lack of jurisdiction.
Could you try to speak up? Yeah.
Yeah, I'm in trouble as well.
Maybe the mic.
Podium adjusts also, if that's easier for you.
Each of the petitions for review should be dismissed or denied for a variety of reasons, ranging from a lack of jurisdiction to a failure to identify what will improve any error by the agency. I'd like to begin today by talking about the court's jurisdiction to review the NRC's petitions.
I just said, before you get into jurisdiction, I just have a factual question. So maybe you can answer it. This site's going to have about 40,000 tons of waste, right? And isn't that right? And there's another one 40 miles away that's going to have more waste. Is that right?
That's generally correct. I would just note that this is the first phase of the first facility, but there is potential for expansion.
Yeah, I understand. Is this all the nation's current nuclear waste from power plants, or a percentage of it?
It's a substantial percentage. I don't have the exact figures, but it is a lot. And certainly the amount of nuclear waste that gets generated increases over time because we are operating reactors. But this is a substantial amount of fuel that has been generated. Let me begin with jurisdiction, if I may, because I think that provides the lens through which to view all the issues that have been presented today. And I'll begin by saying that under the Hobbs Act and the Atomic Energy Act, this court's jurisdiction to review licensing decisions of the NRC, i.e. proceedings in which we granted a license and for which a hearing is available, requires a petitioner first to have come to the agency and invoked its adjudicatory proceedings under 10 CFR Part 2. And this court stated in NRDC versus NRC that the way to get to this court is to submit admissible contention. And I'll note that there are sort of two offshoots of it. One is that if you're admitted to the proceeding, then you get to appeal the final license that's issued by the NRC. If you're not, then we're in a situation where you have the immediate right, within 60 days of the denial of your request to intervene, you have the right to seek review of the agency decision that denies your request to intervene. And that's what, in the main, the petitioners did with regard to their first wave of petitions. And we don't deny that those petitions for review are properly before the court. But with regard to the second wave, the ones pertaining to the license itself or the EIS, those are not matters that are appealable to this court because the sole remedy for someone who's not admitted as a party is to seek judicial review of the decision denying party status. Now, that has immediate consequences for this case, and it has two sets of immediate consequences. First is that petitions, sort of what I'll refer to as the follow-on petitions that post-date the issuance of the license, those the court should dismiss for lack of jurisdiction. Let me just note with respect to that on page 4 of the reply brief, Don't Waste Michigan and Sierra Club do assert that, well, this rule that I've articulated somehow doesn't apply to NEPA claims because the NRDC case didn't involve NEPA. I just want to point out to the court that that's not correct. In fact, the only issue that was before the court in NRDC was a NEPA issue. The court made a statement that I referred to here, talking about how to get to this court, you need to provide admissible contention. But the second takeaway from the sets of rules that are articulated and their applicability to this case is that the court's review here is confined to the question about whether the agency acted reasonably when it denied admission of various requests to intervene. And when considering that question, we need to understand that what the agency did there was to interpret its own rules concerning contention admissibility, and in particular 10 CFR 2.309, and in applying those rules to the various contentions that have been raised. Now, petitioners have raised a number of arguments in their briefs, and we've heard some of them today as well, suggesting that somehow that the NRC's rules aren't fair. Well, I want to make clear 2 points about that. First, that's not what this case is about. This case is about the application of the NRC's rules to the NRC's application of the rules to this particular set of circumstances. Second of all, this court has repeatedly endorsed the NRC's rules. It has upheld them in response to official.
We understand that.
And I know I promised 2 points, but I'll raise a third one too.
And this argument doesn't address the beyond nuclear arguments or the Faskin.
Well, I think it's fair to say that that question raises a question of law that the agency looked at de novo. And in that sense, we're not talking about a reasonable application of rules, or we're not talking about arbitrary and capricious review or use of discretion. We're talking about the agency's legal judgment. And I certainly am happy to speak to that if the court has questions about it.
I mean, you can use your time however you want. But this is just narrowing the scope of what's before us for one of the three petitioners. So you're going to have to address each of the three pieces anyway.
Let me just finish the jurisdictional point, and then I'll move from one to the next. The idea that's been asserted here that somehow the environmental impact statement is immune from judicial review, or comments on the environmental impact statement are immune from judicial review, is incorrect. And the reason I say that is because the rules are set up, and again, this is rules that have survived this court's scrutiny.
I'm sorry, I didn't understand what you just said. That somebody's arguing they're immune from judicial review?
The argument has been raised that the NEPA comment process is essentially a dead end for petitioners who seek judicial review of the agency's disposition of those comments. And I want to make clear that that's not the case.
But is your point that we don't have jurisdiction over the challenges to the environmental impact statement?
Certainly, that's one of my points. Yes.
That's your point, right?
Yes. I'll move on from that then.
Yeah, okay.
Understanding.
I think we got that.
Let me begin with Beyond Nuclear. And I want to make clear that the provision at issue here is not a grant of authority to the NRC to do anything. Rather, it's a restriction on what, and not a grant of authority to the licensee to do anything. It's a restriction on what the licensee is permitted to do. And it's a means of ensuring, as the NRC's mission necessitates, that there is financial assurance provided by the licensee that they're not simply going to walk away, that they're not going to declare bankruptcy tomorrow and leave the nation with stranded waste. So what they've done, or what the agency did, is to address contingencies that may arise, perhaps because Congress decides to revisit this issue, and to make clear that no matter who the title holder is of the fuel that's being stored, that there will be financial assurance provided so as to ensure public health and safety. And that's what the NRC is in the business of doing. This condition is a means not of granting affirmative authority to do more than what the law provides, but rather to just make sure that there's no concern that the licensee won't have funds to ensure operation.
So I was wondering so the position that you're stating now is also what is reflected in the Commission's ruling on this issue. I was just wondering if we owe any deference to an agency's interpretation of its own license, a license that the agency issued. That doesn't seem to fall neatly into any of the deference doctrines, yet it seems to be something that the agency issued. The agency has stated what it meant when it issued the license, and I just am wondering if we owe any deference to that.
I don't know that a traditional deference doctrine applies, but as the court's questioning before, I think suggests, the NRC will abide by the representations it makes to the court, or that a statement in a judicial decision that we expect the NRC to adhere to its statement made in its commission decision, that it will not authorize the storage of DOE titled fuel if that's illegal, and as long as it's illegal. So in that sense, I think that the commission's statement that this is not permissible is entitled to, I don't think deference is the word.
For the DOE to take title to fuel, would it have to go through the NRC? Would the NRC have to approve that?
DOE to take title to the fuel.
Because you're saying that you would stand by what you said in your license, but I'm wondering if you have any role in that.
I think that as a technical matter, this is outside the purview of the NRC's jurisdiction as to what DOE is or is not doing. But what I can say is that if the licensee's requirement is to provide proof of contract, and if the contract that it relied on in order to satisfy the condition were illegal, the NRC would say, no, you can't give this to us. This isn't enough. You can't be, you need to have financial assurance, and proof of financial assurance via an instrument that's illegal doesn't satisfy your obligation.
So that would have to go through the NRC again if there were actually a contract?
It wouldn't have to go through the NRC, but the NRC would enforce, pursuant to its enforcement program, requirements of all licensees.
So you're saying somebody would sue and then it would come before the NRC and you would say that's not?
That's one vehicle. I think another vehicle is a suit by someone who doesn't like this outcome under the Nuclear Waste Policy Act. There's a specific judicial review provision of the NWPA, and if someone wanted to make the assertion that, hey, DOE, you can't do that, it wouldn't necessarily be a case against the NRC, but there would certainly be judicial recourse in that circumstance.
Even apart from the question of who might bring what lawsuit, your position is that notwithstanding the reference to government-owned waste in this condition, it would not be presently lawful for this licensee to make arrangements with regard to government-owned nuclear waste.
That's correct, Your Honor. And the one point I'll make too, in response to Judge Hand's question earlier, is that I think it is fair to say that the central premise of this license, as it's been presented to the agency, and that the agency has based its evaluation on, is in fact that it will be storing spent fuel from, or to which private entities, i.e. NRC reactor licensees, currently own title and will continue to hold title. And if one were to look at, for example, the purpose and need statement in the environmental impact statement, you can see, this is on page JA 1070, you can see that the way that the agency has analyzed the project is in response to the demand of private fuel owners to have an off-site place to store spent fuel. Not talking about DOE taking title, we're talking about private licensees doing something with the fuel that they currently own title to and continue to own title to until and unless it changes.
So do you agree with my prior line of questioning about focusing on the contention itself and its framing of what the central premise is? If we agree that this is not the central premise, isn't that reason in itself to uphold what the commission did in this case?
I think that's a fair conclusion. Yes, Your Honor. It's one of several, but it's certainly one of the ways the court would rule, and we would have no objection to it.
And if we ruled that way, would we have to address all the ins and outs of this potentially illegal application of the license?
I don't think the court would, no.
Because there was a statement that we would still have to decide the motion to dismiss, and then we'd still have to get into these issues. What do you think of that?
I don't know that the court, I mean, first of all, let me back up on the motion to dismiss. There hasn't actually been any briefing about what the agency did wrong vis-a-vis the motion to dismiss. So
I'm sorry, there hasn't what?
Hasn't been any briefing or any argument from Beyond Nuclear about, although they referenced the resolution of the motion to dismiss as one of the items that they're seeking review of, they haven't in their brief argued what it is that the agency did incorrectly.
Oh, I see.
Now, we referred those arguments to the licensing board because that seemed like the appropriate thing to do. These are issues that we want to be able to adjudicate. The way we adjudicate things is through our 10 CFR Part 2 process. So it seemed, and the motion to dismiss isn't even something that's contemplated by the NRC's regulations. So in an effort to accommodate, is the best word, arguments that had been raised and to give persons an opportunity to be heard, we channeled those arguments to the NRC's adjudicatory process. I plan on moving to the next phase unless the court has additional questions about Beyond Nuclear.
Yeah, that probably makes sense.
Let me move to next to the Fasken. And the general theme of what I'd like to say is simply that the agency acted reasonably in ruling as it did that the contention that had been raised was both untimely because the various facts that had been presented as new were in fact either A, not new, or B, certainly ascertainable from the existing record. And that B, even if these arguments had been timely raised, they still wouldn't present an admissible contention. Let me focus on the latter half first. I heard Mr. Tanner say earlier that the focus of the arguments that he wanted to make and that distinguished his claim from those presented by Sierra Club and Don't Waste Michigan and that had already been addressed by the commission were somehow pertaining to the local flavor of the impacts that were going to be experienced in terms of transportation to and from the interim storage facility. The fact that Fasken has identified that somehow opened Fasken's eyes to new information here isn't a fact that has to do with local impacts or localized impacts. Rather, this is at page 4-74 of the EIS, which is JA 1070. This comes in as a part of the discussion about nationwide what the impacts of transportation to and from a consolidated interim storage facility will be. And it's talking about national impacts, or the impacts on the nationwide shipment of spent fuel from Maine, Washington State, or Florida to Texas. And what's interesting about that is that that discussion has nothing to do with Texas or with New Mexico or anything like that. It's about a nationwide shipping. And in fact, the page of the draft EIS that was the basis for the motion to admit new information, which is page 4-75, actually says two things, and they're rather interesting, is that they illustrate that there's really no contention here to be raised or any problem that's been identified underneath it. The first statement is that, well, we actually don't expect any additional significant costs to be incurred for emergency planning or emergency preparedness along this nationwide travel network, because in fact, those emergency preparedness costs are already being incurred by various states and municipalities as a consequence of the existing radioactive and hazardous shipment traffic across the nation. So we don't actually expect any additional costs. So to the extent that the assertion here is that, oh, there are going to be more costs, well, that's belied by the text of the provision itself that FASN is relying on. The second point is really just that that statement does, the statement that talks about what will happen if, in terms of alleged additional costs, what it's really saying is that, oh, we just want to point out that in the event that DOE were the shipper, i.e. in the event that we're talking about a national shipping campaign to Yucca Mountain, there would be grants available under the NWPA, the Nuclear Waste Policy Act, and these aren't NWPA shipments, so therefore there will be no additional grants. Those aren't costs of this project. It's just pointing out that unlike a national shipping campaign to Yucca Mountain, these are going to be costs incurred. These will be costs that will be incurred by the shippers themselves with federal grants. So essentially, there's no federal windfall, no federal backup, nothing more. It's certainly not a cost or a deficiency in cost analysis related to this particular project. Let me briefly reference some of the arguments that Don't Waste Michigan and Sierra made. Mr. Taylor referred to the arguments concerning transportation as the most important ones for the court to consider. But what I'd like to point out is simply that the argument to this court is simply that, well, the agency should have provided more, or should have agreed more with the conclusions that his experts or the experts that he cited, rather than, and in particular, should have adopted the worst case scenario analysis that had been prepared in connection with the Yucca Mountain application, and that it's somehow error for the agency to go with a different analysis. But that's not a cognizable criticism of an EIS, either before the agency or before this court.
If we were reviewing the merits of the EIS and it had said, agency had said, we have all these studies and we don't find credible the competing study, or we're not going to do a worst case analysis or whatever, and we're reviewing for arbitrariness, you win, no doubt. But this is a different posture. Here, the question is, what did that study create a genuine dispute of material fact, which seems to mirror summary judgment language, just for the limited purpose of being admitted into the record? And if you think of it that way, and you posit different studies reaching different conclusions, and if the right analogy is to summary judgment standards in civil litigation, it should come in.
2 points, Your Honor. First, I don't think that that's quite the proper analogy, and the commission went.
I'm not sure it is. I was just struck by the language in the reg that seemed patterned on Rule 56.
It's similar to, but I think it's important to stress that it's not. And the commission has, and this is in the same set of cases that have upheld the commission's contention and admissibility standards. It wanted to make clear that a petitioner or an intervener has a burden that's more stringent than summary judgment in order to raise contention before the agency. And again, those rules have been addressed and challenged on appeal and confirmed. But what the commission's precedents have indicated, and this is what we cite in our brief, and also what this court's precedents have indicated, is that when you're coming in challenging an analysis on an environmental impact statement, it's not enough to just say, well, you should accept my people and disregard yours. You have to come in and actually say, what is wrong? Why would it be unreasonable for the agency to rely on the analysis that, in this case, the applicant provided? Or why would it be wrong for the agency to rely, to demonstrate why it would be wrong for the agency to rely on the on the analysis in final environmental impact statement. You have to come in and say it would be unreasonable because of X, Y, Z reason. You have to come in and say that I have someone who knows what they're talking about, most usually an expert, saying that this analysis is inaccurate or that it's flawed to a point where it's unreasonable.
Judge Tatel, anything further? Judge Pan?
No.
Okay, thank you.
Thank you.
Thank you.
Thank you. May it please the court, Brad Fagg for Intervenor Interim Storage Partners. Just a handful of things to go over. First, just a little bit of elaboration on your question, Judge Tatel, about the amount. And it is true it's 40,000 MTUs, metric tons of uranium, ultimately, potentially, if all the phases play out. This particular license is 5,000 MTUs, and the joint appendix at 1969 identifies that. So just that as a threshold.
Still seems like a big number, but go ahead.
A few words about the Nuclear Waste Policy Act arguments. This license is not and should not be a mechanism to enforce DOE's compliance with the nuclear waste policy. If DOE were to do what the petitioners are concerned about, enter into a contract that, with utilities or with ISP that they say violates the Nuclear Waste Policy Act, there is a ready-made mechanism to challenge that. The Nuclear Waste Policy Act itself contains judicial review provisions. There's a number of cases out there, but the Alabama Power case in the 11th Circuit, 307 F3rd 1300 is one of those. Almost the same situation here. DOE entered into a contract there involving compensation. Allegations were that it violated the act, and the 11th Circuit ultimately struck that down. That mechanism is in place. In response to some discussion about severing, should we just eliminate this issue? Two reasons to not do that. One, it's not illegal for all the reasons we've described. This is not an authorization to do anything. This is a restriction on what can be done under this license. And secondly, it makes no sense. Some of the amicus, both NEI and even the NRDC, talk about all the bills that are floating around out there. I get these alerts. It's too many to count.
I'm sorry, the what?
The bills introduced into Congress that are floating around. The possibility, I don't think anybody in this courtroom would disagree that the nuclear waste program in the United States is broken, but there's always and continues to be efforts and potential to change that landscape. This was a years-long process, an expensive process, and if magically, or not so magically, but something happens to change the landscape to say, well, okay, now you got to go back and do it all over again, makes no sense. And again, because of the lack of illegality and the lack of sensibility, we don't think there should be any blue penciling that went on with respect to the license. Final point on the Nuclear Waste Policy Act, there was some discussion about going back to the motion to dismiss and the original contentions. We did talk about that in some measure at pages 17 to 18 of our brief, of the Interim Storage Partners brief, and at the joint appendix at page 40 is the Commission's treatment of that motion to dismiss. It was procedurally improper. So for that reason alone, if that's all that's left of the Nuclear Waste Policy Act arguments, that's yet another of what we think are many mechanisms to reject that part of the challenges here. Moving from that, unless there's any questions about the Nuclear Waste Policy Act, to the NEPA sort of violations, I think it's important to emphasize the standards here. In these types of cases, everyone always sorts of recites the standards review and then moves on. But when you look at, I think, and with all due respect, fairly, the allegations that are being made here, all of the things that are recited about the deferential standards review. NEPA is a series of judgment calls, the Duncan's Point case cited by the government. NEPA determinations are only reversible for a clear error of judgment. These are just disagreements about, we wish you had done it a different way. This isn't the agency said black and the facts are white. Okay, this is judgment calls, and I think, and I would like to emphasize that the traditional deference applied in these sorts of situations is outcome determinative.
I take your point, but what's your answer to my question that all of that said, the bar should be a good bit lower when the question is simply whether the submission should be admitted into the record?
Two responses to that, if I may, Your Honor. First, I would agree with government counsel. By design, it's not a summary judgment bar. It's not a low bar. It's a by design. And then secondly, the rules are not on trial here. Okay, the NRC's rules have been ratified over and over and over again by this court. There's a way that you can challenge those rules. You can petition for a rulemaking, or there's all sorts of ways to do that. But the only thing that's at issue in this case is whether the agency reasonably applied its rules. And the rules, we suggest, are crystal clear. And when you frame it in that way, I think, again, the deference owed to the agency here is very unlike the sort of, well, is there an issue of fact? Is there a possibility for disagreement? That is not the standard for these consequences. So moving on from the standards, I really just have one more point with respect to the Faskin arguments. Mr. Keener asked, well, how was I to know? How was I to know that there might be private storage here private transportation here without the backing of DOE funding? Well, the answer to that is in the environmental report itself. It's at page 767 of the joint appendix. And that talks about if DOE is involved, there'll be funding. Obviously, it's crystal clear from that recitation that that wasn't the only type of transportation scheme. So, unless there are further questions, those were the points I wanted to make. And thank you. Yep.
Thank you.
Thank you. I'd like to make 2 points. In response to Judge Pan, I just want to clarify that we do not concede that our contention was properly dismissed. The issue of ownership and responsibility for the cost of storing spent fuel is central, that the inclusion of any language in that license condition has to be read. All language is central to that license condition. It may be the most important thing in a license. Who gets the bill for this spent fuel if there are problems with this facility? And I think NRC would agree this is an extraordinarily important matter.
So if I can ask you then, like the language was the central premise of ISP's application is that the U.S. Department of Energy will be responsible for the spent fuel that is transported to and stored at the proposed interim facility.
And that's absolutely true, Your Honor. The way
but this ignores that there's an alternative way to do it, which is through the privately owned.
As long as the DOE is in there, you must assume that the DOE will be the owner.
Why must I assume that?
Because that is how the license is written, or means it could be one party or it could be the other. And it's just as likely to be the federal government the way this license is written. All of the assertions about how this isn't going to happen are outside the scope of the license.
There are 2 alternatives. One is lawful, one is unlawful, presently unlawful. Why would we assume that that will shake out with the unlawful alternative?
Because the administrative procedure,
Especially since that's what the government has told us.
why should we rely? Why is the NRC issuing a license it knows has an unlawful provision? That's the first question. Why are we having to litigate whether it's okay to put unlawful language in a license and say, no problem here? As Mr. Fagg said, why would we, why waste our time by making us amend a license?
I understand your position, but I think that you did not reflect your position in your contention. So I think that your contention fails on its face.
Ron, I respectfully disagree because every term in that license is central. The DOE, the fact that there's
then what's the
lawful
point of saying
language in a
central?
license doesn't excuse the unlawful language. That is also clearly established in the courts. All of the language in the license must be considered central.
Well, why would you use the word central if every word is central?
Because it is a central issue in this license. Who gets liability for this spent fuel? That is one of the important conditions in the license.
Okay.
And I would just.
Thank you, Mr. Kern.
Could I add one more
Briefly.
point? to Judge Tatel as why can't we rely on the assurances of the court that you would not let this condition be fulfilled? Again, it begs the question as to why we're jumping over hurdles to legitimate unlawful language.
We understand that. Yeah.
Thank you very much.
Thank you very much.
I can hopefully clarify Judge Katsas's questions about whether this is like summary judgment or not. It is not. The contention admission process is more like notice pleading and a motion to dismiss. You
think it's even a lower burden?
Pardon?
You think the burden is even lower in this context?
Oh, yes. And in fact, the NRC regs provide for a summary disposition after the contention is admitted and there's some record made.
What do you do with the cases? I'm just looking at the cases cited at page 52 of the red brief. We have a fair number of cases suggesting that even at this admissibility stage, the proponent of the evidence has to not merely suggest other ways this might have been done, but point to a deficiency.
Well, first of all, I think we did more than that by presenting our expert testimony and our evidence we presented. We have put in our initial brief under standard of review cases from the agency itself indicating that the NRC has determined that the burden on a petitioner in stating its contentions is not heavy. Simply insisting upon some reasonably specific factual and legal basis for the contention, and that the petitioners are required only to articulate at the outset the specific issues they wish to litigate. The petitioner only needs to come forward with factual issues, not merely conclusory statements and vague allegations. And there is a Supreme Court case we cited, Vermont Yankee versus NRDC, that says that the intervener simply must make a showing sufficient to require reasonable minds to inquire further. I think we've done that. And just as the court can rule on a motion to dismiss at the pleading stage, I think you can rule here. I think you have the jurisdiction to do that. Thank you.
Judge Tatel? Judge Pan?
Nothing else.
Thank you.
Thank you, Your Honors. A fair reading of the Fasken contention would include all of the information contained in the Taylor affidavit, the motion itself, as well as the words of the contention itself. It does have a local flavor. We focus primarily on local issues. What the NRC is saying is, but we don't deny that there are some national facts here. Remember, the environmental report and the EIS talk about safe transportation nationwide. We're not talking about local situation. And they do it based on DOE shipments 100%. Can I
ask you about that? Because looking at JA 767, the environmental report says, if the DOE is the shipper, the federal government through DOE is responsible for providing emergency training to states, tribes, and local emergency responders along the transportation routes where SNF would be transported to the CISF. So isn't that by implication if DOE is not the shipper? I mean, this leaves that open. So why isn't that ascertainable to you? Why didn't you raise this in response to the environmental report?
Okay, fair enough. It's not, because if DOE does this and they say nothing about the other scenario, and if all of the safety data is based on DOE shipments in the past, then I don't think a reasonable person should read into the all of this other stuff.
But the implication is DOE isn't always the shipper. If DOE is the shipper, this happens. And I think it's ascertainable that there may be instances where DOE is not the shipper So why are you not on notice that that could happen?
I think it's ascertainable that the privately titled waste will be shipped, but the question is who will ship it and under what standards. Nothing is said in the DEIS or the environmental report other than referencing these studies based on DOE shipment standards, which I think we all agree are elevated to what the NRC could do, but we haven't been told what they're going to do here. I don't think IF goes that far, and I think that the issue focuses on the information, there's no reference to ascertainability in the order. The order that I'm appealing specifically says we agree the language is different. So let's just talk about two things. Let's talk about material differences, and let's talk about the local emergency issues being beyond the scope of what we're doing. And I think that's what we focus on, and we need to focus on here. I would say that the agency can't ignore its own site-specific rules. And finally, this whole premise is the agency ignoring all of its rules about ISFSIs, all of its rules about MRSs, creating a new situation to move virtually all the nation's SNF to two facilities without any of the security that we would have had at a place like Yucca Mountain. And they do it with this whole new thing that keeps changing. That's extraordinary, I think, by any, and it's worth noting, every single contention was rejected in this case. That's unprecedented. Over 2,800 comments were basically ignored because the final EIS didn't reflect any changes from the original DIS. That is not how the agency and the public deserve to have this kind of decision made. Thank you. Unless there's a question.
Thank you.
Thank you.
Thanks to all counsel. The case is submitted.
Case number 21-5223, Perioperative Services and Logistics, LLC, appellant versus United States Department of Veterans Affairs. Mr. Tolching for the appellant, Mr. Dreyer for the appellate.
Seems like you're not the big draw this morning, but we're interested nonetheless, so please proceed.
I appreciate that. So my name is Ed Coach, and I'm here representing the appellant in this case, Perioperative. And we're here on a FOIA, but it's kind of a unique FOIA, not one that I've previously handled or seen, in which we're actually trying to figure out what to do when this court effectively decided the matter based upon a declaration we didn't see and on which we can't comment because we've never seen it. And then withheld a document under FOIA based on a secret declaration, and they didn't even see the document in camera that they're withholding. The district court didn't see the document in camera. So I'm gonna
It's not an ideal situation, but I mean, we've seen a lot of FOIA cases, and it's not that unusual to have a declaration that explains the basis for withholding without revealing the information that the government is seeking.
No question. But that declaration is then provided to physicians so that they can see it to the extent that it doesn't disclose what it is they're trying to protect. Here, we're given nothing. And that really comes down, that really is the nut of this problem. The government's justification for what happened here is that Hubbard, United States versus Hubbard, which is the lodestar of what to do, doesn't apply, and
But you're
just
not,
is not right.
you're
It
not,
doesn't.
let me just make sure I understand what Hubbard applies to a situation where you're trying to obtain, the question here is whether or not the district court properly relied on an ex parte declaration, right? You're not seeking under FOIA that declaration, correct? You're just arguing that the district court shouldn't have relied on, right? So
That's one issue.
So this is not a Hubbard case. This is controlled by Arif.
No,
No?
I disagree.
Okay, tell me why.
Because the Tierney Declaration is a judicial record. That's why Hubbard applies.
But you're not seeking a copy of that in this case.
Well, in order to argue
Isn't that
about,
right? I mean, you might, and then it would be a Hubbard case.
it's a two-step process. In order to argue about.
Can I just ask you, are you seeking the Tierney Declaration? No, right?
In order to argue about the two-page document, we're seeking the Tierney Declaration so that we can argue about the two-page document. It's a two-step process. We can't even begin addressing the underlying issue in this case because we haven't seen why it's being withheld.
You took Hubbard in the abstract and asked yourself how it might apply to this kind of situation where you have a FOIA requester and the government says, we need to justify the withholding, but we can't do it without letting the cat out of the bag. And you ask yourself how those 6 factors would apply to that kind of situation. Wouldn't you get something pretty close to Arief anyway?
Right?
Okay, so what are we fighting over?
But I don't think Arief says that we don't get the Tierney Declaration. I think all Arief says at the bottom is that you've got to look at a balance of privacy versus public. That's all it does. And I think Hubbard basically does
The government doesn't dispute that.
Well, okay, but what?
So we're not talking.
I'm sorry.
No, I mean, we're not talking about a legal disagreement between two noticeably different standards. We're talking about whether they met their burden of showing that they need to tell us a little bit more without revealing things that they're entitled to protect.
I think at bottom, a lot of tests that courts develop are based upon an amalgam of information and an amalgam of standards. And you can always watch them together and say, let's look at what's reasonable. And I don't disagree. Arief is reasonableness. Hubbard is reasonableness. Hubbard sets out 6 factors. Arief looks probably at 2 of the 6 factors. But the bottom line is that what Arief said is that if you have a lot in the public already and you're just missing something, and we have got to understand as a court why it is that we're redacting a small thing and it's not in the record, we can look at a declaration beyond what's already in the record. In this case, we have nothing. In other words, if there was a Tierney Declaration that we saw and it said whatever it said, but there was something unique that Tierney couldn't say publicly, and that was in a separate declaration, then you would have an area type. But here we have nothing. We're sitting here arguing about something that we can't address because we haven't seen anything. Even in their brief, they disclosed something about the Tierney application, the Tierney Declaration, which we had never known before. But when you look at it, it made the Tierney Declaration an improper declaration because it was argumentative.
It does make your job harder, no doubt. But let's talk about a few things you can talk about, which is the merits, the balance on the merits. And it seems like we have a lot of authority for the proposition that a person who comes forward with information, provides information to the government, has some privacy interest in not having his or her identity just divulged within exemption 6. You agree with that?
The case is going both ways. And I tell you what I think the difference is.
Really? What?
Holland is one very good example.
I'm sorry, which one?
Holland, we cited a whole bunch of them in our brief. And I can find it. I just saw that earlier this morning in our reply brief, but there are a lot of cases in which the district court, the U.S. District Court of the District of Columbia addressed these issues.
How about from this court?
There's not much in this court.
Okay.
There's not much coming out of this court, but it's really all the same kind of law, because what the courts have said and what basic reason tells you is that you've got to look at something and say, is this really a privacy? How much privacy? How important is the privacy? And you look at, you say, well, this person, whoever it was that submitted this, he wasn't an anonymous complaint. He put his name on something and sent it to the U.S. government. So privacy, somewhat limited. Okay, now public. What is it that we need? We need to see how the government looked at this, and part of it is where it came from. Was it from a friend? Was it from was from a competitor? How do they look at that? So you look at the privacy, which is limited, and the cases have said that when somebody submits something to the government and puts their name on it, that privacy interest is extremely limited. And you look at the public need, and the public need is to figure out what the VA did. Or
what the government is up to is a standard phrase we use in FOIA cases. So what would this record, now you haven't seen it, but suppose it's just information, it's the allegation that your client sold defective products. That doesn't tell you how the government investigates. How would the complainant know that? He's not an inspector general reviewing the agency's investigatory process. He's a complainant saying your client sold bad products.
Oh, did the complainant come from somebody who was a competitor? We don't know. Did the complainant come from somebody, was the complainant somebody who actually never dealt with my client? We don't know. Was the complainant somebody who has the same last name as somebody at the VA who acted on this? We don't know. We don't know any of it.
So you're saying that the identity of the complainant is critical to what?
It's possible. The identity of the complainant is very important, but
you're weighing, it's the privacy versus your interest in the identity, and maybe you lose.
But if we had the email with that information redacted, we might say, well, we don't need. Now we can see what happened here. We don't need the identity, because we see in the email that this person is saying, I work at a hospital and these people delivered.
But the allegation is, if you see the email, it will reveal the identity, which you're not entitled necessarily to have.
So that's the allegation that is beyond my credulity. I don't understand how looking at an email where information is redacted, addresses and names are redacted, we would know the identity of the person who submitted it. It's just not. It just doesn't make any sense. If the person said, I'm in a hospital in, I don't know, Atlanta, Georgia. I'm in a VA hospital in Atlanta, Georgia. Okay, redact VA hospital in Atlanta, Georgia. But tell us it was a hospital. If the person says, I know that striker beds were what, because we think that that's what the complaint was, because we heard something in an oral conversation, or my client did. If we find out that it's really not striker beds, it's some other product that my client has never sold anywhere, we would be able to respond more forcefully. But the bottom line is that we know nothing. And the reason why we know nothing is because everything has been in a sealed brown bag, and we've been given no. I
mean, you're interested in the identity.
What's that?
You want to know the identity of the accuser, right?
We might. But without looking at the information without the identity, we can't even argue why we need the identity.
You admitted in your brief that you want to know the identity. You want to unmask the complaint?
There is no question my client would like to know the identity. And the reason is because if this person is an outlier, I want to sue them.
I don't blame you for that, but right. I mean, let's not beat around the bush. That's what this case is about.
That's what my client would like to do. Would not sue somebody for libel or slander, or it's probably libel, defamation.
Yeah.
But that's not harassment. That's not.
No,
that's not the privacy interest that the government can protect. The government has no right to protect somebody from a libel suit. That's just wrong. The government has the right.
But it's a little bit unrealistic to then frame this as, you can redact everything that bears on the identity, and they release a document that, says this came from a Yahoo email address.
I always tell my clients, let's go step by step. If we see a document without the identity, maybe that will be enough. If we see the document, we might need the identity. That's step two. But without looking at anything, it's like arguing about ambiguities. We have nothing.
Don't you want a redacted version so that your client can try to piece together what the identity is? And isn't the government's position that we don't know what your client knows, so if we reveal any of this, they might be able to unmask?
I'll answer that in two ways. Okay. No, that's there. As I said, there are two steps, and I would tell people there are two steps. Let's look at the document without it, so that there's nothing that would possibly identify the person. That would be step one. Let's look at the tyranny declaration as to why they say they can't do that. That would be certainly part of the step. And two would be the answer. The answer is that if we want that information, it's because we have a legitimate interest. It's not an illegitimate interest. All the cases that they cite about harassment, they know we want to harass us, are all about their abortion clinic protesters who want to go in and beat up women who are going into an abortion clinic, or physicians often. It's that kind of harassment that the cases are concerned about. It's not. They're never concerned about. In fact, this court has said we're not concerned about potential lawsuits or potential litigation that might develop. It's because that's not a legitimate. That's legitimate harassment if you want to look at it that way. But it's nothing that should prevent us from looking at this information. But again, we haven't seen the tyranny declaration. We haven't seen any part of this email. We're talking about nothing. That's what we have, nothing. And that really is what this comes down to. Can the U.S. District Court decide a case based upon not giving us any information?
Thank you, Judge Tatel. Any questions? Judge Pan, anything else?
No, thank you.
Okay, thank you. We'll give you some time. Rebuttal.
Good morning. May it please the court, Douglas Dreyer on behalf of the Department of Veterans Affairs. There are two issues here. First, the district court acted comfortably within its discretion when it accepted the tyranny declaration ex parte. And second, VA appropriately withheld the complaint under Exemption 6 for the reasons stated not just under seal in the tyranny declaration, but in the three public-facing declarations in this case. FOIA does not compel agencies to unmask a whistleblower in a case like this one.
Let's talk about that. Put aside the information in the ex parte declaration for now, which might present case-specific issues. I mean, just as a general matter, you do have cases on your side saying there is a privacy interest in, complainants have some privacy interest in their identity. But is there any requirement that that be a legitimate privacy interest? And I mean, suppose the person coming forward is a competitor with malicious intent who makes a false charge and substantially harms the FOIA plaintiff here. And sure, they want to bring a defamation action, but be a perfectly good action.
So the privacy interest must stay focused on the interest of protecting the identity of the individual complainant. And there could be good, significant public interest reasons why the identity of a complainant should be disclosed. Perhaps there's less of an incentive to protect the identity of an individual who's submitted a malicious complaint. But I want to emphasize that's not the case that's here today. So in the answer, for instance, the defendant denied that the complaint was false. The defendant has certainly never conceded that there is a false complaint here. And Also, I think where the focus has been is on the investigation eventually lifted the recall. But that is not in any sense a determination that the initial complaint itself is false. I also would like to focus on the particular request at issue here because I do think the words matter. And the words particularly matter in this case where my friend narrowed the FOIA request. So on page 15 of the joint appendix, the request is narrowed to, quote, the redacted form of the 2-page document, i.e. not the substance, and the identity of the person or entity submitting the complaint. That is all that is being sought here. And so it's directly contrary to what we were hearing earlier in the argument about what the reasons is. They explicitly disclaimed it seeking basically just the identity of the person. And so that's really what we're here today on.
So I had a question about the Tierney Declaration. And so the case law says that a district court relying on in-camera submissions must make its reasons for doing so clear and make as much as possible of the in-camera submission available to the opposing party. And it seems that there was a request both in the motion for reconsideration and in the prior brief in the court below to at least give us some of this. And it seems to me that the district court did not address the option of redacting the Tierney Declaration and giving some of it to the FOIA requester. And so I'm wondering if that's an abuse of discretion where the court says it must make as much as possible available to the opposing party, and it has to make its reasons for doing so clear. I don't see any explanation that it was considered redacting the Tierney Declaration and giving some of it to the opposing party.
So I think what's important here is that the defendant filed a motion for leave to file the Tierney Declaration ex parte. And in that motion, it provided significant contents about the Tierney Declaration. And that's not in the joint appendix, but it is ECF number 12, I believe, perhaps 10. It's either 10 or 12, sorry. But in that motion, it identifies the name of the declarant, it identifies the title of the declarant, and it provides what defendant was able to say in a public-facing setting. And so the district court gets presented with this motion with that information already on the record. And so and I would read the last 2 pages of the district court's opinion where it addresses this issue as really saying that, look, this information, to the extent it should be disclosed, it already has been in that.
Does it say that? I don't see that here.
It doesn't use those exact words. No, Your Honor.
So wasn't the court required to make its reasons for doing so clear? Those are the words of the Armstrong case. So you're coming up with a reason, but that's not what the court said. So I'm wondering if that's an abuse of discretion, and if so, is there harmless error here?
Well, I'd say, so the district court, for instance, it cited Barnard at the end of its opinion. So in the Barnard case, which is another district court opinion, the court did include the district court included a footnote explaining that it had assessed whether it could segregate any portions of the declaration and provide a public version, and determined that it could not. And I think it could be read into the citation of the Barnard decision that occurred here.
There's no parenthetical or anything about Barnard. It's just cited. So you think that's sufficient to make its reasons for doing so clear, citing Barnard?
I do, Your Honor. And again, I'd also submit that the motion itself has already disclosed the disclosable, to the extent there are disclosable portions of the Tierney Declaration. Those portions were submitted in the motion itself.
But there's no way for the opposing party to know that because they don't know what's in the Tierney Declaration.
And that's, FOIA is an unusual case. And Arif pointed this out long ago, that this is really a case where the court's job is to determine whether to maintain material under seal. And so, one party knows the contents of the withheld records while the other does not. And the courts have been charged with the responsibility of deciding the dispute without altering that unequal condition since that would involve disclosing the very material sought to be kept secret. And so it is very difficult to provide additional information without forcing the government to concede its case in its briefing.
I think that's different from what I'm asking, because it seems to me that you could redact the Tierney Declaration to preclude disclosure of the information that might disclose the identity of the complainant. And it seemed to me that this case law suggests that the district court was required to either do that or explain why it did not.
And to that, I suppose I would say that to the extent there was any error below, it would still need to be not a harmless error. And here, since the motion itself disclosed contents of the Tierney Declaration, disclosed the name of the person, the title of the person, I don't see how any error relating to that would be anything but harmless.
Your position, you think you can win on the merits now, even if we were to disregard the information in paragraph 8 of Tierney, which might help you out. But if we disregard that, we're left with some reason to think that this was a competitor, the charge was false, may have been malicious, and it caused substantial damage to the complaint. And your position is just tough.
Well, my position is that the Tierney Declaration was indeed essential to the district court's opinion and needed.
Tierney might make the case substantially different from what I just described, but I'm just testing here whether we need Tierney for you to win.
The defendant does think we need Tierney to win, and the reason why is because...
Sorry, thinks you do need it?
Yeah, we need Tierney to win in this case, and the reason we need that is because, when the court looks at the test that was set forth in Arif and looks at the test set forth in Montgomery just this past July, one of those the requirements of that test is that the validity of the exemption you need the information being provided ex parte in order to decide the validity of the exemption. And so if I were to answer that alternatively, then the Tierney Declaration would perhaps never have, should never have been filed in the first place.
Yeah, I see that. I think you're entitled to argue in the alternative, but I appreciate your candor on that. Judge Tatel? Okay, thank you.
Council cited to Appendix 15 as something that limited this. But look at the Appendix 15. What that is a letter from me saying, as an initial limited release. In other words, we're saying you've withheld everything, and you've withheld it on the basis of Exemption 5. They didn't even withhold it on Exemption 6. They withheld it on Exemption 5. And our position was, if you're withholding it on Exemption 5, as a limited matter, you have to at least initially give us something that's limited, because Exemption 5 clearly cannot apply to what it is you're withholding. That's what that letter is about. It has nothing to do. It doesn't limit this our request. That's just wrong.
So it says in your letter, we ask that A, the redacted form of the 2-page document be released, not the substance.
Read 2 paragraphs up.
And B, the identity of the person or identity submitting the complaint be released unredacted from the form document. So that does seem to be narrowing your FOIA request.
So read 2 paragraphs up. I am asking for a prompt initial limited release, and it goes on in the next paragraph to explain that Exemption 5 cannot apply to what it is that we're asking for a limited release, and you're denying us. In other words, they said, we're not giving you anything, Exemption 5. I said, well, that's crazy, because Exemption 5 cannot possibly apply to this stuff, so give us the initial limited release, and then we can fight about everything else, and they wouldn't give us that either. But that doesn't limit this case. That's clearly not what's happening. The court asked us about cases in which this has occurred. People Throw American Away. We cited that case. We cited the case of Edelman, in which complainants, which people writing the government letters complaining were released. Their response was, well, look at Edelman 3, because there was additional litigation in Edelman. And that's true, there was. But in Edelman 3, it said, well, we're going to withhold the last X number of names because you already have 50 other names of the complainants, and these last ones are just in the same category, so you have no real need for these names. So it's clear that releasing names is de rigueur. That's really what should have occurred here.
Thank you. Judge Tatel?
No.
Judge Pan? Okay, thank you. The case is submitted.
Case number 22-5074, ITServe Alliance, Inc., appellants versus United States Department of Homeland Security. Mr. Forney for the appellants, Mr. Press for the appellate.
Morning.
Morning. Thank you, Judge Katsas. May it please the court. Jeffrey Forney for appellant, ITServe Inc. Please like to reserve 2 minutes.
Try to talk in the mic. I'm not hearing it very well.
ITServe's members have suffered and continue to suffer increased operational costs due to the rule USCIS announced in matter of Simeo, which the agency imposed prospectively, without exception, on all H-1B employers through a policy memorandum that was issued contemporaneously with that proceeding. However, the rule in Simeo was not the product of an adjudication. Rather, the agency wants to characterize it as such, but the proceeding was not an adjudication. It doesn't have any of the typical features of an adjudication. Rather, it sounds as a legislative rule. The agency has imposed it on the regulated community as such.
The agency had before it the question whether Simeo Solutions had improperly failed to get apply for the second visa, the amended visa.
Thank you for the question. The characterization may require some qualification. It wasn't a visa that was at issue. In that case, Your Honor is correct that the proceedings leading up to the appeal before the AAO did involve the foreign national appearing at a consulate for a visa interview, but that wasn't the crux of the matter.
Now, I may have the immigration terms wrong, and I apologize for that, but if I do, but I'm just making the point, the dispute came up in the context of what we would call a case or controversy if it were in an Article 3 court. It wasn't just the agency musing in the abstract. They had an actual dispute before them, and they had to resolve it. And in the course of resolving it, they had to construe this language in the agency regulation about what it means, what the phrase material changes means. Seems about as adjudicatory as you can get.
Well, the administrative record suggests otherwise.
Suggests what?
Suggests otherwise. The government produced in the administrative record a rather interesting letter that was issued to Simeo, who is the putative party in the case. That letter indicated that around 2011, the employer had already asked that its petition be withdrawn. And under the regulation, that request resulted in an automatic revocation of the petition.
But is there evidence that, I understand that letter, is there any evidence that Simeo withdrew that letter, not just before the appeals office ruled, but also before the director of the California service issued its letter? In other words, is there any evidence it was withdrawn before that decision?
Well, all we have is the administrative record, and in Appendix 70, that letter in which I referenced indicates that a letter of withdrawal or revocation was ordered on September 23, 2011. Therefore, the approval of your petition is automatic.
Was that before or after the original decision?
Well, the letter of withdrawal revocation was ordered well before the decision issued in the AAO.
Before the appeals decision?
Yes.
But doesn't it have to have been ordered before the original
I
decision?
couldn't hear you.
Doesn't it have to have been withdrawn? Your point is that the withdrawal of that made this not an adjudication, correct?
Yes.
There's no evidence that it was withdrawn before the original decision.
Which original decision are we talking about?
The office's decision.
Administrative Appeals Office decision?
No, before that.
Well, there were only two decisions at issue in this case. The first was the approval of the petition. Well, then there was a revocation by the agency. And then there was the AAO proceeding that resulted in the published order by the AAO. This letter indicates, at least with the dates that we see here, that the petition was automatically revoked well before the AAO proceeding. Of course, by definition, it would have been automatically revoked after the original petition was approved.
But
that's what the revocation involved.
Wouldn't the agency need to know about the revocation at the time it issued its opinion for this to matter? And there's nothing in the record.
I'm having trouble hearing you.
Oh, sorry. Wouldn't the agency need to know that the petition was revoked at the time they issued their opinion? And there's no evidence in the record that they knew that. We can only review what's in the record before the agency.
Well, the letter in the administrative record, which the agency produced as part of this record of proceedings, contains this letter of automatic revocation.
I'm just saying it's not clear the AAO knew about it because it's not in the record that the AAO was considering.
Well, it is. The AAO actually produced this record. It was certified by an official of the administrative appeals office. It's in their record.
Okay. So I actually have a different question for you, and that's about the case Conference Group, LLC, and how it applies to this case. And Conference Group held that in a situation such as this, you have standing to contest the rule to the extent it's a rule, but you do not have standing to contest the adjudication. And I'm interested in how that applies in this case, because it strikes me that if you want to challenge something as granular as a letter that allegedly withdrew the petition, that seems to me to be an attack on the adjudication and not the rule. The rule is the general principle that when you move your H-1B recipient to a different location, you have to amend your petition before the agency. But these sort of granular case-by-case things, such as this beneficiary lived in Long Beach, but he was working in LA, the petition was dismissed in the middle of this appeal, that seems to me to be a challenge to the adjudication and not the rule. And Conference Group suggests that you can't challenge the adjudication.
Yes, I appreciate the question. I think some of the confusion that revolves around this issue maybe is the way in which the district court judge viewed that. And I think Your Honor is sort of reiterating that position, and it's understandable, but the critical point is that we're not challenging any particular aspect of the putative adjudication, including the letter at issue that we've been discussing. That we're not challenging that. That letter is merely indicative of the fact, among other points, that this is not an adjudication because of what happened in the proceeding. Its characteristics, including the characteristics tied to that letter, show that it was prospective only, in effect, had no direct bearing on the putative party in the case, because their petition that was supposedly at issue is no longer live. The AAO, therefore, was addressing an abstract issue. That kind of characterization, at least according to this court's precedent, brings it over to the rulemaking side of the paradigm.
You're saying that, I'm just trying to understand the distinction between challenging an aspect of the adjudication, which is that the petition was dismissed, and not doing that, but instead using it as evidence of that this is a rulemaking.
Yes, precisely. Because an adjudication has two characteristics. case-by-case fact sensitive in which the agency addresses those facts and during the course of the proceeding may come up with a principle.
I understand all that, but basically the Simeo record is not actually before us. You are not a party to the Simeo proceedings. You are just trying to challenge the precedential effect of the ultimate holding of the Simeo ruling, which is what you think is a legislative rule. But to do that, you are getting into the details of that Simeo proceeding. And it strikes me as procedurally strange that you should get to do that.
Well, and this goes back to, I think, Your Honor's point about conference group, which, as I believe you correctly pointed out, suggests that a non-party to the case can't challenge the adjudicative aspect of an order that appears to affect. Of course, there's a couple of material points of distinction there. One is that, of course, the court found in that case there was an adjudication. We're contending here that this is not an adjudication. Its characteristics, among other things, the characteristics that appear in the administrative record show that it was a rulemaking on adjudication. The second, more critical point is that the party in the case challenging the rule in the conference group, the court noted that they would have actually had the opportunity to challenge the application of that rule or precedent that the agency formulated in a separate administrative proceeding to distinguish that case and show that they did not fall within the ambit of that precedent rule. That's not the case here. There's no procedure by which any member of ITServe can do that. Therefore,
I'm curious about that. Why not? When you apply for that, can't you say it's our position that if this person moves, we shouldn't have to repetition? There's no vehicle to do that?
There's no vehicle to do that. Certainly not in the manner in which was noted in a conference group, which the FCC, of course, had a more elaborate procedure in that case where the Bureau might review your practices and then you can challenge whether or not your practices require you to pay into a fund, and then you can appeal that to the FCC before you incur any financial losses by being held to pay into the fund. That type of proceeding isn't available.
I want to ask you about, so that was one way you distinguished conference group, but there's another way you distinguish conference group that I want to ask you about. You say in your brief that the plaintiffs here failed to show that the challenged action would, and this is a quote from your brief, would have a pending certain harm, and that unlike here, but in conference group. The court, we were very clear there that the adjudication that the plaintiff was challenging there had found that companies like Petitioner, a particular type of telecommunication services, would have to contribute to the Universal Service Fund. They found that our case was based on that, and that sounds just like this case. They did show some harm, namely they had to contribute to the Universal Services Fund, right? They had to pay into the fund, and there was no question about that. And your client has to pay more for these petitions, and I don't see why they're different. If it wasn't enough in the conference group, why is it enough here?
So I understand that conference group, one of the critical points was that, again, I think there's two critical points. One is that it was unclear that a non-party to that case was actually required to pay into that fund. The only order at issue was that the conference group and related parties who were subject to the FCC's order were compelled to pay into the fund because the order was directed to them. The order wasn't directed to any other party, and moreover, more critically, separate parties could actually challenge in the future whether the FCC was going to apply.
No, I know that argument. I get your argument about that. I was just asking about this, what seems to be a separate argument in your brief, that unlike here in conference group, they had failed to show any impending harm. And it looks to me like they did, that they would have to pay into the Universal Services Fund.
Oh, well, if Your Honor is indicating that the parties in the conference group did show an imminent harm, is that?
Yes.
May I misunderstand the question? I'm sorry.
Yeah. Well, you said in your brief that they didn't. That's why I asked you the question.
Right. I mean, I think the case stood on the principle that they couldn't show impending harm because the order didn't apply to them. And they could
Because what?
Because the order did not apply to the parties in the judicial proceeding. I mean, that's different here. We have a different situation here because the policy memo that was issued contemporaneously.
And your whole distinction of conference group turns on your argument that there's no other remedy here for your client, right? There's no other way to challenge it other than through this APA.
That's true.
Right? That's your distinction for conference group.
That's the primary distinction.
Yeah.
So I'd like to come back to that because I think it's important. But it seems to me that you could challenge this in one of your client's proceedings because one of your, members could apply for the H-1B visa, get it, their person could move, they could get the LCA but not petition. And when they try to deport that person, you could raise all the issues that you're saying now, but that is not appropriate. All of your substantive arguments, such as now you're intruding into the Department of Labor's area. So you could challenge all of this. It wouldn't be pleasant for the H-1B visa person who's the beneficiary, but you could challenge this within one of your own visa applications.
Well, I'm sorry, this gets into some technical nuance about immigration. I apologize about that, but Your Honor mentioned challenging that type of issue in a removal proceeding. The employer can't be a party to a removal proceeding that's specific to a foreign national where the Immigration and Customs Enforcement alleges.
How did Simeo bring it?
Well, the foreign national issue in that case was outside the United States at the time. He had gone to a consulate to get a visa. Initially, he was working for Simeo.
I'm just trying to understand how Simeo brought that because you're telling me that none of your members could bring the case before the AAO.
Well, because there's no way to ventilate this issue before the agency, before the harm is actually suffered. In other words, the agency laid down a global rule of general applicability that applies to the members. It says, if you're going to move folks, file the LCA, but then you have to file an amended petition, full stop. And associated with that amended petition is the, of course, filing fee and other transactional costs. So you incur that harm before you can go to the agency and say, hey, we don't think this applies to us. There's just no procedural mechanism to raise that issue.
Can't you move for declaratory relief like in TIVA?
The agency, to my understanding, has no procedure to petition for a declaratory order. I mean, the FCC has a regulation, for example, which, of course, this court knows well about because it's.
But you could ask for a preliminary injunction. It just seems to me that it's not clear to me that you don't have a way of raising this issue other than attacking Simeo.
Well, there's no way of raising the issue before the agency, before the harm is incurred.
Why can't you move for a preliminary injunction?
Well, of course, that would require civil action, which is exactly what we did. Filed a civil.
Right. So why can't you do that? Why is you sort it?
So we did file civil action. Of course, the district court below dismissed on various grounds. So that's what we tried to do.
No, but you brought a civil action attacking Simeo. I'm saying why not in one of your members' own cases can't you litigate this?
Because there's no way for the issue to be triggered before they actually comply with the rule in Simeo. And then when they comply with it, there's no way to actually go to and file a civil action and say, hey, we want to...
You would have to not comply, right? You would have to not comply and then move for a declaratory judgment or a preliminary injunction or let it proceed where you're beneficiary gets deported and then you approve. But it's just not clear to me that you cannot litigate. Well, there's no way to litigate.
Right, but like in conference group, there was an administrative proceeding to ventilate that issue before any actual harm. What Your Honor is suggesting is to flout the rule that USCIS put forward in Simeo, wait for an enforcement act.
That's what conference group would have had to do too. If somebody wanted to challenge this in their own case, they would have had to probably flout the conference group rule and then litigate it.
Well, right, but it would have been ventilated through the Bureau, who had delegated authority to hear the issue, and the party could have raised the points before the Bureau and then had an administrative appeal before the FCC. That type of proceeding isn't available.
Then I just don't understand why Simeo could do it and none of your members can.
Simeo could do it because they were actually the named party in the case, but of course they weren't anywhere they didn't actually appear in the appeal. So let's be clear about that.
But I'm just saying that issue was brought to the AAO. Simeo brought that issue to the AAO, and you're saying it's impossible for any of your members to do so.
Technically, Simeo did not bring the issue for the AAO. It was certified by the district director. So Simeo did not appeal. It was certified, of course, after the petition had been revoked.
Okay. My point is simply Simeo brought that to the attention of a rulemaking adjudicatory body, and I don't understand why none of your...
Well, it didn't, because it didn't appear in the proceeding at the AAO. At least there's no indication in the administrative record that they appeared. But of course, if they chose to appear, that would be...
I guess my question is, Simeo happened. How?
Well, Simeo, I think is how you pronounce it.
Simeo. All right.
It happened because, of course, they were a party to the administrative proceeding. It was their petition. The revocation proceedings involved their petition, and the certification to the AAO involved their petition. So, of course, they were a party in that administrative proceeding. The whole point here is...
So then what happened? So they say their petition was found to be insufficient, and then it went to the AAO, right?
Well, it was certified to the AAO.
Certified to the AAO. And why can't that whole process happen with one of your members?
Because there's no way to bring up that issue before compliance. And if you fail to comply, then what happens is, as indicated in the agency's policy memo, you can be sanctioned. The employer and the foreign national is out of status and put into removal proceedings. Those removal proceedings are not a vehicle by which the employer can challenge any of these issues. Immigration judges don't have jurisdiction.
Thank you. I understand.
Can I just briefly on the merits ask you this rule or adjudication question? It's obviously significant for standing, but assuming we get over that hurdle, on the merits, you want to call this a rule in order to argue that the agency failed to comply with notice and comment rulemaking. Right. And your main reason for saying that is that they changed their mind on how to interpret material changes in the regulation. And that would have been a winning argument under our decision in paralyzed veterans, but that was unanimously reversed by the Supreme Court. So, I mean, even if this is a rule, it's obviously interpretive. So your notice and comment claim doesn't get off the ground either way.
Well, I agree with you if we were talking about the agency changing course through the same proceeding. I believe, I think it was mortgage bankers where the Supreme Court took issue with the paralyzed veteran, Alaska professional hunters, I think, the original case. But that's not an issue here. We're not raising the point about the agency, changing course in the same proceeding. Of course, it is a different type of proceeding, but that's largely irrelevant for our argument. The argument is you have a statutory provision which doesn't address the issue, doesn't mention it. Agency publishes a regulation with a broad, open textured term like material change that changes with the facts and circumstances of the case. There's no way to flesh out the meaning of that term except through further legislative rulemaking. If you flush out the meaning of that rule, you're necessarily putting flesh on it in a material way that would require removal. That's what the agency did in matter of Simeon. That's what we're finding to be procedural.
Okay. Judge Tatel. No. Judge Pan.
No, thank you.
Thank you. We'll hear from the government.
Thank you, Your Honors. Joshua Press from the Department of Justice here on behalf of the Department of Homeland Security. Mr. Payne, I want to get right to your question about, seems sort of critical here. Is there a procedure by which one of ITServe's member companies could challenge Simeon? The answer is absolutely yes. And it is, this type of situation happens very frequently. In fact, today, there are numerous H-1B visa petitions with applicants in India who left during the COVID-19 pandemic. They are waiting, sometimes very long periods of time, but they are waiting with very old LCAs, very old H-1B petitions that were previously approved by USCIS, and they're waiting for a consular interview. And the reason I bring that up is the exact same fact pattern that occurred in Simeon could occur with those H-1B visa applicants. They would be beneficiaries. To be clear, the companies that are sponsoring them are the applicants themselves, per se, but the beneficiaries are the ones who have to go for the interview. It was in that precise factual context where the consular officer from the State Department, which Katsas was pointing out, makes a determination as to whether to issue the visa. Now, that is slightly different than, to be sure, what USCIS does and what the Administrative Appeals Office, the AAO, did in this case. But I think the critical point in why Simeon was necessary for USCIS and the AAO to actually adjudicate and issue a presidential decision on, that they were seeing this fact pattern again and again, where essentially sponsoring employers would try to game the system by including a lower wage area of the country. And then they would sort of use consultants in specialty occupation visa applicants to go to many different places across the country for 6 months or years, instead of the actual wage rate that was initially determined, I think, within a 7-day period of time, long ago by the Department of Labor. So when the consular officer sees the blatant mismatch between what a visa applicant is telling him or her, oh, I'm going to work in Hoboken. Hoboken, for better or worse, is not Long Beach, California. And that actually sort of raises a line of suspicion with the consular officer. They might think, well, why are you lying to me? They might think, is this guy a security threat? And they have to do follow-up with that. So the follow-up in this case was,
sorry, you're talking about the initial.
Oh, yes, I'm sorry. The follow-up in Simeon was, hey, you need to check out the initial application, the labor certification, the labor condition application that the Department of Labor approved as a prerequisite within 7 days. And to be clear, they're only looking for completeness and for obvious inaccuracies. So they're not going to catch if the work site gets substantially moved across the country.
This problem arises when an H-1B recipient comes into the country to work in wherever, Long Beach, and then is moved to Hoboken.
Yeah, it could easily arise in that because.
Is there any mechanism? What's the mechanism at that point for judicial review if short of DHS notices the violation, the lack of a second filing, they deport the alien, the employer is not a party to the deportation proceeding, but then somehow once the alien has been removed from the country, that seems to be the posture in which Simeo came up. Is that the mechanism?
Right. Well, the normal mechanism would be if DHS or USCIS actually understands that the initial petition grant was made under false pretenses. Mm-hmm. They could revoke the petition, or they could issue a notice of intent to revoke, and they could flag for the employer who is the actual.
Sorry, DHS does that?
Yes.
Okay.
And they could flag, hey, we noticed that your Department of Labor condition application said Long Beach. It looks like the actual beneficiary is working a lot in Hoboken, which is
Has a different
$9,000 differential in the average wage rate, which I think for an applicant who is getting about $50,000 a year is a 20% difference. It's a big difference. You need to respond to us, or otherwise we're going to revoke the petition that was previously granted. That would leave them unable to employ the applicant. And the beneficiary would then be out of status if that status gets revoked. That does not mean they might not be able to change status to something else. It also does not mean they're going to.
When DHS notices that violation and does what you're describing, is the action against the employee or the employer?
The employer. Now, the deportation proceedings or removal proceedings that are under the INA now, those are against the employee, the beneficiary, individual applicant. But that, I want to be clear here, we're not talking about any sort of scenario here. Any of ITServe members, employees today, if they're here on H-1B visas, who, being threatened with deportation because ICE, Immigration and Customs Enforcement, is a separate sub-agency within DHS. They make that determination. And they have their own prosecutorial discretion, their priorities, and that's all under very different litigation from this one. But that's sort of that I'm hoping to explain the procedural posture that DHS uses. I know it's very complex.
Can I just ask, so when the agency issues the notice of intent to revoke your petition, can you appeal that? Can
Absolutely.
you move for a stay of that? Can you?
Yes, you can move to reopen or reconsider, or the AAO could take that decision that, let's say, the director's office does revoke, which is we're under a slightly different factual background, but basically in the exact same posture operatively. They could take that revocation. The AAO could do the exact same thing here.
They would have to actually revoke, though, to get to the AAO. The notice of the revocation would not be sufficient.
Actually, the AAO could take it on its own if it wanted to.
Okay, even before the actual revocation takes place?
Yes, that's very, very rare because, of course, they like to have something, actual development for them, but it could happen, I believe. Nonetheless, the proper way to challenge that, I think the core of what we're trying to argue in our briefing and what we argued below with regard to standing and conference group, the proper way to challenge that is to bring an action in district court challenging the revocation as arbitrary and capricious in violation of the APA. They could talk about Simeo or however you call the company's name. Of course, they're not here to actually pronounce their name. There, as this is an improper application of that, or that rule, or the adjudicative rule that was laid down in that opinion by the AAO is ultra vires or something along those lines.
There's no specialized review scheme that would attach to that. The INA is just, of course, chock full of these things that tend to.
Not beyond the AAO. The AAO would be the limit for within DHS, and then it would be up to a plaintiff employer or employee.
You could go to district court through the APA without having some kind of channeling argument.
That's correct. And that happens. It's not uncommon for that exact scenario to occur.
I was going to change the subject.
Go ahead.
Go ahead.
Assume I think they have standing to raise their argument that this is a rulemaking in the guise of an adjudication. Okay, just assume for a minute that that's what I think. What's your best argument that this is in fact an adjudication?
Well, it had immediate impact to Simeo Solutions in the sense that they could no longer employ that employee whom they actually had petitioned for, whom they ostensibly wanted to employ. And it, of course,
what about their argument that they had withdrawn the petition before that?
Frankly, I was also frustrated by the record in the sense that I didn't nothing.
Me too. So can you help us?
Well, there. I think in terms of reading the opinion from the AAO, it reads not as well as Your Honor's opinions here, of course, but I mean it is a judicial opinion in that mold, to be sure. And I just don't think anyone can claim otherwise. Now, in terms of adjudicative facts that were there, they were presented with a clear record, a problem that they were seeing. Now, it's not, it wasn't a general problem that you would normally see in a notice of proposed rulemaking. It was actual circumstances of specific locations, specific wage rates in different metropolitan statistical areas, visa applicant with a consular interview. Those are, I don't know how to say it, real world facts And they were applying what they saw as the INA and their regulations, i.e. law, to facts. And that's what we see in an adjudication, differentiation from rulemaking, which is policymaking via actually announcing a rule, having notice and comment, discussing, weighing benefits and costs.
Okay, so let me go on then to, so you also say that that they don't have standing to raise their other arguments, not just the argument that this is a rulemaking in disguise, but they can't raise their other arguments, and you rely on conference group for that, right?
Yes, there's a lot of discussion.
Yeah, so is conference group, I'm just curious, in conference group, that was a petition for review, whereas here, they filed an APA action just like in TIVA.
Yeah.
Does that make a difference?
Well, I think the core of our standing argument is that, frankly, they could never actually show a definite time that one of their members were subject to Simeo, other than once in the course of litigation, but they actually could never show anything beyond someday intention of filing other H-1B petitions.
Okay, well, suppose I think their declarations are adequate.
Okay.
Okay, what's the other argument?
I do think that if you apply Judge Silverman's opinion for the court conference.
If you do what?
I agree with what you're getting at, is that the conference group does make this differentiation between it as whether it's an adjudication that's being reviewed or as a rule being reviewed, and the same sort of scenario could support standing for one, but not another. That is, if it were a rule, they would have.
No, let's assume I agree with you that it's an adjudication.
Okay. I don't think they would have standing because then they're a mere bystander, than Judge Scalia pointed out. It would be the same thing as someone coming in.
And what do you do with TIVA?
Well, I think in TIVA, the contrast is that they were actually pointing to a date certain. And frankly, we've never presented with any date certain other than, well, we might file 63 more of these within that.
Well, but they have affidavits telling us exactly how much this is costing them and how many applications they're going to have to pay for in the next year or two.
Yes, but I think that's my point. Is it's projecting 63 within the next 3 years and how projections of what it might cost is far from impending or certain or actual. And I think that's the distinction that we're trying to make between this case.
It's an awfully fine line. I mean, their affidavits are pretty clear. The declarations.
Well, I respectfully disagree with that just because I would read those things as what might occur within 3 years, considering what we've all gone through in the last 3 years, as something intentions. And if something's coming up within the next 6 months and they could point to that.
Well, what else should they have said? What more should they have said?
I think they would actually say, we have this employee. We believe that he or she is going to need to be moved from X location to Y location with a different wage rate. And if we don't actually, if we're not able to do that, we're certain that USCA will revoke that petition.
But that's an argument about the imminence of the future injury. It's not an argument about, is this an adjudication or is this a rule?
Right.
And I thought that was the whole point of TEVA. I mean, you have Scalia, but I have Tatel, right? I mean,
I'm not going to get into that.
I mean, TEVA seemed pretty persuasive on that point, right? If you have a rule, if you have an adjudication, there might be reason for thinking like, who knows how it's going to apply in some future case. But that doesn't prevent a non-party to the adjudication from saying, look, it established a perfectly clear principle of law, whether we call it a rule or not, and it's going to have an imminent impact on me or my members.
So I agree with what you're saying there in terms of, and this is the distinction, same distinction in conference group, because there are two analyses on standing, two different distinctions. I just think that if you're going to talk about TEVA, the distinction was that they could actually point to it.
Was what?
Sorry?
Just say, I didn't hear what you said. If you're going to talk about TEVA, ...
Yes, relying on TEVA for standing purposes in this case, I think is a vastly different circumstance because there was a date certain. There was a date certain. And so I think the Supreme Court case that came to mind imminently was Abbott Labs, where a pre-regulatory challenge of we're sure that this regulation is going to go into effect on 5 months from now, and it will then cost us millions of dollars. That's a completely different separate situation from, well, we think we might file 63 petitions within the next 3 years, and if we had to do that, 63 times about $460, Sorry, I went to law school because
But it's really, again, maybe I'm repeating myself, but that's really a question not about rule versus adjudication. That's a question about whether this case falls within Lujan's someday intentions.
That's correct.
Point.
That's correct. Exactly. I agree.
The district court, though, found standing based on the business model of the member companies. Is that appropriate? It says the court finds based on the member companies' business models, they face increased costs because of Simeo.
Yes, so we disagree with that. We respectfully disagree with that on that approach, because essentially any employer could say our business model requires us to shift people across the country. They still need to show imminent or impending injury, and that requires more than someday. Frankly, we read the affidavits and never anything more than someday intentions, and that's why we.
No. Okay, thank you, Council.
We ask you affirm.
Thank you. Just 2 points. Your Honor, I guess I do need to correct a statement. I see your point. I've just reviewed a conference group again, and for standing purposes on challenging the rule, Your Honor is correct. The court noted that they actually did show additional financial costs because of the regulation. Nevertheless, later in the opinion, what hinged on the matter was that the conference group could go and before the Bureau and the FCC before they paid costs to the fund. That's just not available here. And on one of the points that my esteemed opposing counsel mentioned about those types of proceedings challenging an H-1B revocation is that the revocation actually has to be entered before an appeal to the AO is taken. But what the critical point here is that the employers in this regulatory regime suffer an immediate harm and consequence, unlike what was in the conference group, because what they do is risk not only revocation of their petition, but then the foreign national being out of status and being moved. And therefore, if that happens, of course, they have no vehicle necessarily to challenge that revocation because they no longer have an employee here in the United States. The removal proceedings take place separately. They have no standing in that matter. And if the court doesn't have any other questions, I think that does.
Thank you. We appreciate the 8 seconds. Seated back. The case is submitted.